Welcome to the WN Legal Podcast.
Welcome to WN Legal's podcast. My name is Q. I'm from WN Legal itself. Today, we'll be dwelling into the topic of drugs. Now, before we go on, we'd like to say that the the discussions I'm having today, they don't constitute legal advice. They're just discussions about the specific scenario of what would happen or what may happen if you're caught in those set of scenarios or circumstances. Even if you were caught in those set of circumstances, they still don't constitute legal advice. I would still recommend that you speak to a legal practitioner personally before you start following through with some of the things that were said. So I don't recommend that you follow through with what I'm saying until such time you've spoken to someone else or even myself. Okay. So the topic is about what happens if drugs were found not on you, not in your property, but related to you by a remote or far-fetched possibility. Can you still be charged? So this kind of situation happens when, for example, there's a parcel addressed to your property and you don't know what's in the parcel. And it may be drugs. And if it was indeed found to be drugs, what would you do and what would happen? It may not be in a parcel, may not be by post. It may be by a bag with your name on it, or something, or a note saying that, hey, this is yours, or it should be posted to your property. What do you do? And whether can you be charged? So the actual question behind that is whether the police can charge you for attempting to possess drugs. If the drug amount is high enough or is significant enough, sometimes you can be charged with what we call with intent to sell or supply. With intent to sell or supply comes about if the quantity is enough for the court to presume that you can't finish it yourself. And because of that, there is an intention for you to sell or supply. So before we go on into talking about with intent to sell or supply, we first want to talk about the attempt to possess drugs, because they can't charge for possession when it's not in your possession. Possession is dominion and control. That's a classical term that we would use. Dominion and control means that you have some kind of control over the drugs. If the drugs were found in your room or at the dressing table, then yes, you would have access to them. You would have control over them. Therefore, it can be said that you have possession of it. So ordinarily, if police search your house or someone's house and they find that the drugs were on the dressing table, then they can easily establish possession. The question is whether it's yours or someone else. That's something to be discussed at a later time. But that's the general idea of possession. The question today is, can they charge you for attempting to possess drugs? The answer is yes, they actually can. There's a specific section in the Misuse of Drugs Act that talks about that. There's a case law as well. Now, when the police or the prosecution charge you for attempting to possess prohibited drugs, they must establish that there is a nexus or a connection that you have towards the parcel or the bag with the drugs inside there, and they must establish that it's somehow related to you. Now, that's how they would first start off when they believe that you attempted to possess a specific kind of drug. Usually, when they find the parcel in itself, there's not enough evidence to suggest that you have the intention or the ability to possess the drug. They would then go on and find evidence about what we call the preparatory, the ability to prepare to acquire the drugs. So they're going to look at that kind of behavior to acquire drugs. They would then do many things if they in their power to try and find out whether it was yours, whether you're connected to the drugs, and they can even execute a search warrant to do so. So, in the eyes of the law, the prosecution would have to prove that you had put your intention into execution by doing an act that is more than merely preparatory to the commission of the offense, but does not need to fulfill your intention to such an extent as to committing the offense. Now, that's the case of Weggers in the state of Western Australia, 2014, in the Western Australia Supreme Court of Appeal. That means that they don't need to prove the full extent of your conduct or a specific person's conduct to actually commit the offense. But what they have to prove is that your actions is more than merely a preparation to the commission of the offense. That's what it means. That's the threshold and the test behind whether they can prove that you have attempted to possess a prohibited drug. They do so usually by figuring out whether or not you acquired the drugs online, whether you've acquired the drugs through telephone calls, text messages. So these are the things they will look for. They would also want to execute a warrant to find out whether you have books in your house with names and numbers or scales, in fact, to weigh the drugs if they do come by. Clip seal bags is a very common item that they'll be looking for that will show that you intend to petition the drugs, or any evidence of transactions. So, paraphernalia is also something they'll be looking for. So they can show that you are a regular user or not, or a social or occasional user. But all these are indications to the prosecution that you had prior dealings, and they can then establish whether you have a nexus or a connection towards the illicit substance, the drug. So that's how they have to maneuver about in proving that that a person's action is more than merely preparatory to the commission of the offense. They do not, and I repeat, need to actually prove to the full extent of your conduct to commit the offense. So they don't need to say, let's meet at this time and this place, and this drug will be yours. No, but they need to just prove your conduct and the act of preparation behind it. So if I explain to you what the attempt bit is and how viable is that in a prosecution's case, it is viable if they can prove that that there is a nexus between the drug and the accused person. The other thing they have to prove is possession. So once they've proven the nexus, they have to then prove that you have the intention to exercise dominion and control, the intention to possess the drug. So that's what they need to prove next. Now, that probably answers the question for this podcast of whether or not, even if the drug is not in your property or in the accused person's property, and perhaps not related, and only related by a far-fetched possibility or a remote possibility, can a person still be charged? The answer is yes, if the police can prove that there is a nexus. And if the police can prove the terms that I've just explained, and the tests that I've just explained, whether or not they can prove that you have put the accused person has placed his or her intention into the execution by doing something, an act that is more than merely a preparation to the commission of the offense. Okay? So that concludes today's podcast. Thank you for listening.